Hello everyone, welcome to the overview class. This is a bonus lecture for the new criminal laws which are yet about to be enacted. Alright, they will be enacted by July 2024, and so it's very important that we cover the new laws concepts in a consolidated manner. In generally across the classes, I have covered most of the laws that have been introduced. There are some that I could not because they did not fit into any particular category. Some things that skipped my notice that this should also be considered important. Alright, so I have just consolidated this one lecture for everyone so that once and for all you can study the newness of the new criminal laws, the Bharatiya Nyay Sanhita, Bharatiya Nagrik Suraksha Sanhita, and uh, the Bharatiya Saksha Adhiniyam in a consolidated manner. Alright, first we'll study about the new criminal laws. Alright, we'll see what new concepts have been introduced, what new offenses have been introduced, and what are the changes in BNSS and BSA. Right. So new laws, new offenses have been introduced and deleted from the Bharatiya Nyay Sanhita, which is the BNS. But there are also briefly we will cover the BNSS and BSA so that it is just comprehensively covered. It is not likely that a question can come on these lines because the syllabus does not specify that this can be a part of it. But normally the syllabus portions across the previous years have been tending to look at the periphery as well. So just in case a question comes that evaluate the new criminal laws vis-a-vis the old ones, it's better to have a general overview of all three laws. Alright. Just about the basics, that these criminal laws were enacted to decolonize India and to represent an independent nation, an independent republic, and not a colonized state of another country. Therefore, we have chosen the Sanskritized version of Hindi for giving the names of these codes. The first one is Bharatiya Nyay Sanhita instead of Indian Penal Code. Code means Sanhita, Bharatiya means Indian, but instead of penalty, penal code, it is now Nyay Sanhita, which is for justice. Alright, so this is to signal that the uh, aim of the code is now Nyay, justice, and not just punishment. The earlier Indian Penal Code's translation was Bharatiya Dand Sanhita. So that was directly related to Dand, which is punishment, but now it's about Nyay, which is justice. Alright, we'll see some concepts which point towards this. Then we have the Bharatiya Nagrik Suraksha Sanhita. Alright, it is not just criminal focus, criminal procedure focus, but also about citizen centricness. It's about the Nagrik or the citizen and their protection, because criminal procedure can encroach upon the rights of the citizens. So therefore the name, that it is for the protection of citizens, this code has been enacted. And the last is Bharatiya Saksha Adhiniyam. Sakshi is evidence, right? Witness. So Sakshi is witness, Sakshi is evidence, any kind of evidence. So all three of these constitute the new criminal laws, alright, which will be enacted. There are some new concepts which have been introduced. First is a change in punishments. This is in the BNS. That a new punishment called community service has been introduced. Alright. What community service means has not been defined anywhere. So it is up to the courts to decide what kind of community service will they order. That might depend upon the kind of offense. Alright. But the aim is reformatory justice. We will see at the end of this class. Right. So this is a step towards justice, towards Nyay. Then we have a concept of zero FIR. This was already in place by the Supreme Court's order. Alright. but now this has been given legal status because now the law itself allows for it. What is a zero FIR? Let's say you live in a particular place, all right? You live in the east of a district, east district, and now to west district. If you are going, someone commits a crime on you in west district. So you go to the police station near your house and you tell them that someone stole my wallet. They will say, listen, this is not our jurisdiction. That go to the police station in west district because the crime happened there. Police of that region will investigate. So you will have to travel as a victim. You have to travel a lot. All right. The concept of zero FIR first started off in rape trials and then it picked up across the country for all kinds of offences, that you can register a crime anywhere and it is the responsibility of the police officer, all right, the station house officer, to transfer it to the relevant jurisdiction. Okay, this is no longer the citizen's responsibility. Another concept that has been introduced is the idea of digital evidence, all right, that from now on officially digital evidence can be recorded through audio visual aids. So what would happen is, sometimes let's say you are just a tourist in a place, you witness an accident happening in front of you. Now you are called to the court multiple times, ki identify, was this the driver, was that the car, etc. And your time gets wasted as a witness. That what was your responsibility, right? Now digital evidence has been allowed, that you can come to a court, you can through video conferencing, you can sit and you can identify that yes, this seems to be the car, this seems to be the man driving the car, this is what the victim looked like. So all of that is now allowed through digital means as well. All right. Now we have trial in absentia. Trial in absentia basically means that if the accused person is absconding, all right, if they are not present in front of the court cannot commit a trial, all right. So that created a lot of issues, especially in criminal law, because that creates delays and you have to wait for them to surrender. Now trial in absentia have been allowed in criminal procedure so that the trial continues. If a person has been declared guilty by the court, they will directly be arrested and imprisoned, all right. They will not be caught and then they will not be tried. So that gives more reason for people to surrender in front of the law so that they can be tried in front of the law. Otherwise, they will directly be tried, their defense will not be permitted and they can be convicted in absentia. There is a change in police custody provisions. All right. Earlier, police custody, there are two kinds of custodies, police and judicial custody. So offences allow for 60 days or 90 days of custody, of which earlier the first 15 days could go to the police, all right, up to first 15 days. It's not necessary that all the 15 days will be granted, but the police would be granted 15 days of custody. Okay, the difference between police custody and judicial custody is that in a police custody you are under a thana, all right, you are directly under the police, and normally the situation is that police is more brutal and violent, they can also interrogate you. But when it comes to judicial custody, then you are in a regular prison, the police does not have authority over you, the jail officials are separate from the police officials, so therefore they are distinct hierarchies and you cannot be interfered with in a prison by police authorities, all right. So earlier the first 15 days would be police custody. Now under the Nagrik Suraksha Sanhita, any 15 days in the first 40 or 60 days, all right. If it's a 60-day offense, if the limit for that offence is 60 days of custody, then the first 40 days can be spent in any sequence by the police. Alright, the police can say that we need 2 days today and then we will take 2 days next week from custody. Okay, why has this been done? Because many times the agencies would switch. That first the case went to the state authority, alright, that state police, and then either the NIA or the CBI took it. But by the time these agencies would come to action, 1.5 weeks would have passed. So the police would never get custody, they could not interrogate at all. That is why this change has been brought. Alright. Similarly, many times the accused would simply say that I am sick, I need to be hospitalized, and they would be in the hospital for 15 plus days. So the police would never get custody. They would directly go to judicial custody. So to avoid such anomalies where the police does not have time for custody and for interrogation, the change has been brought in the Bharatiya Nagrik Suraksha Sanhita. Alright. Normally this has been told in the news that this will impact bail provisions. We do not have evidence for it right now that will it actually do so, but the suspicion is that if the police can ask for custody across the time period, the courts may not grant bail to a person, alright, because their police custody is pending. We are yet to see how the courts will react to it. Another point is the gender sensitivity in the court, in the Bharatiya Nyaya Sanhita, alright. They have recognized transgender as a gender, alright. They have specifically said that he, wherever it's given, will mean male, female or transgender. There is no male centric purpose only anymore, alright. Transgender, alright. Offenses like voyeurism, alright, and disrobing a woman. We saw in the class on offenses against women that these could only be committed by a man on a woman. Now they have been made gender neutral. Alright, they can be committed on anyone, committed by anyone on a woman. Alright. So these are still offenses against women, but they can be committed by anyone. So even a woman can commit voyeurism, they can leak their photos, etc., or stalk them while they are in an undressed position, etc., etc. And they can also commit the act of disrobing a woman. They can also conduct sexual harassment of these sorts, but it will only be conducted against a woman. So the victim remains a woman. Alright. Besides that, section 377 no longer exists. It used to be carnal intercourse against the order of nature, but that is not an offense anymore. Okay. So section 377, the dreaded section which criminalized homosexuality, is not a crime. These are some new concepts which have been brought in the Bharatiya Nyaya Sanhita and the Bharatiya Nagrik Suraksha Sanhita. Alright. Let's just look at the scheme of the BNS. Alright. Chapter 1 is preliminary definitions. Definitions is a big part and you should go through it, and explanations. So definitions is section 2 and explanation is section 3. Alright. In section 1 to 3. Earlier in IPC, all of this was section 1 to 52A. So now all of this has been clubbed into one single section in section 2. Punishments, which define the kinds of punishment and how half term of punishment, full term of punishment, all of that will be calculated. So we saw in the punishment section that the number of punishments are listed. They have one extra, which is now community service. Alright. And earlier it was in section 53 to 75. Now it's consolidated into 4 to 13. Alright. So 10 sections instead of 22 sections. 23 sections. Alright. General exceptions, pretty much exactly the same. 30 sections, section 76 to 106 was the earlier law. Now it's section 14 to 44. Alright. The order remains the same so far. Alright. After this, when the actual offences begin from section 45, that is when there is a change in order. Alright. Abetment, criminal, conspiracy and attempt, all of these were separate chapters in the IPC. They were not together. Alright. In fact, criminal conspiracy was in the chapter of offences against the state. Now, the BNS makes them chapter for sections 45 to 62. Alright. Instead of chapter 5, 5A and chapter 23 for attempt, general attempt section 511. All of that has been combined. And we have chapter 5, which is offences against women and children, sexual offences, all of those offences. They have now been clubbed and brought ahead. Alright. Now it is section 63 to 99, which are offences against women. Earlier, offences against women were scattered, that in section 354, ABC, etc. That was in offences against the human body. And then section 376 was very late. Now it is brought to the forefront to show that the security of women is the top priority of the government. Alright. So earlier it was section 312 to 318, 354, 366 to 376, some sections missing in 16, 20, 28, and then 509, insulting the modesty, eve teasing. Alright. So this was scattered, now it has been consolidated. Then we have the remaining offences against the human body. Alright, this is now chapter 6. Earlier it was chapter 16. Alright, then we have offences against the state, chapter 7. Earlier this was chapter 6. So you see that the citizens have been brought thematically, they have been brought above, that they are given more priority. State, which earlier was a top priority, is now given a much more rear view seat. Alright, offences against public tranquility, it is now chapter 10, well it was now chapter 11, earlier it was chapter 10. The section is 189 to 177. We saw that the corresponding sections were 141 to 157. Alright. Offences against property broadly remain in the same range. Alright, they are chapter 17, but now they have shifted about 90 sections ahead, 80-90 sections ahead, from 303 to 334, whereas theft began from section 378. Alright, so that is a major difference. So this is the general scheme of the Bharatiya Nyaya Sanhita. This is the changed priority, changed number of sections. Alright, we will also study some of the new crimes that have been introduced. Sexual intercourse by deceit, we have covered many of these. Some minor portions we have not covered, we will just cover it. Alright. Sexual intercourse by deceit, we have seen organized crime and petty organized crime, terrorism, treason, snatching, mob lynching, trafficking, and hit and run. Alright. These are some of the offences which have been introduced. Sexual intercourse by deceit, we have already studied this in the offence against women section. Alright. By employing sexual intercourse by employing deceitful means. Alright. So this is not rape anymore. Earlier it used to fall in the category of rape. That also led to a lot of false complaints and a general bitterness in people that women are filing false complaints because of bad relationships. Now that will be a separate offense, so that a person is not called a rapist and clubbed together with the other kinds of rapists. Alright, whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same, alright, has sexual intercourse with her, such sexual intercourse not amounting to offence of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So there is no minimum punishment for it. Alright, whereas for rape there is. Explanation: deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. right? So if you lie about who you are, that you might say you are a rich person, you might say that your family is so and so, etc. All of that, if you do, and you deceive a person, that will be an offense under this act, section 69. And simultaneously, if you also give a false promise that you marry me or you have sexual intercourse with me and I will give you a job promotion, that is also an offense. All right. There's a new provision which is introduced, gang rape on minor girl, section 70, clause 2. Section 70 is gang rape. All right. Where a woman under 18 years of age is raped by one or more persons constituting a group or acting in furtherance of a common intention. Right? This is just the offense of gang rape that we have already studied. All those persons shall be deemed to have committed the offense of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, with or without fine or with death. Alright. So, minor rape has been punishable with death, which is not the case with otherwise gang rape. Alright. This is gang rape alone. Otherwise, gang rape with murder is punishable with death. Alright. Provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Alright. So this is also victim compensation focus. This was also in the IPC, because this is not very old as a provision. This was introduced in 2013 only. Alright. Provided further that any fine imposed under this subsection shall be paid to the victim. That the fine has to be just and reasonable and it has to be paid to the victim. Alright. Then we have section 103, which is mob lynching. Okay. The official description is not mob lynching. The official description is punishment for murder committed by 5 or more persons. Alright, where a group of 5 or more persons acting in concert, alright, similar language, commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground. Alright. So basically on that person's identity markers, if there is a murder, all members of such group shall be punished with death or with imprisonment for life and shall be committed to shall also be liable to fine. Right. So this has now been made a separate offence so that it's easier to establish guilt instead of the regular unlawful assembly. Alright. Grievous hurt by mob. This is basically same, where a group of 5 or more persons acting in concert causes grievous hurt instead of murder to a person on the ground of race, caste, community, sex, place of birth, language, personal belief or any other similar ground. Each member of such group shall be guilty of causing grievous hurt and shall be punished with imprisonment of either description, a term which may extend to 7 years and shall also be liable to fine. Right. Grievous hurt causing permanent disability or persistent vegetative state. This is also looking at past experience that people have committed such grievous hurts which have led to very severe consequences. Alright. The normal condition is that grievous hurt is supposed to have happened if you cause bodily pain of 20 more days. Now that bodily pain has also been now been reduced to 15 days instead of 20 days. Alright. Whoever commits an offence under subsection 1, which 117 is grievous hurt, and in the course of such commission causes any hurt to a person which causes that person to be in permanent disability or persistent vegetative state, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life. Alright, so this is a minimum, not be less than 10 years is the minimum that you can punish. Alright, if this is the consequence that is caused. Alright, another section is hit and run, punishment for causing death by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police or magistrate. soon after the incident shall be punished with imprisonment of which may extend to 10 years. Alright. So for rash and negligent driving, the general punishment is 5 years. But if you run away, that is section 106, that will lead to a punishment of 10 years. Okay. This is to ensure that road accidents get reduced. Currently, India has almost 1 lakh road accidents every year. So it's very crucial that India starts allowing for a regime of reporting of road accidents, even if a person is the perpetrator. That if you commit a road accident and person dies, you think it's better to flee, because otherwise police will put you in jail. And many times it happens on a highway. Most of the time, in fact, it happens on a highway where there is no other witness. So it's only you and another person. So many people run. If they are caught, then there is a much greater punishment. It's double the punishment for the previous offense. Right. Then we have organized crime. Alright, any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom, by any person or group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Alright. So it's not necessary that the activity is committed by multiple people. Okay. Let's say you are a person, a member of a gang, and you alone go and threaten 2 people that you give us money or we will otherwise we will hurt you, we will hurt your family, etc. So but you go as a member of a gang, so either jointly or singly. All right, so you go as a member of a gang. You can also be a general individual criminal, that you routinely do this, that you are the extorter in in an area, that you constantly go and you routinely threaten people. So then you will not be charged once. If it's a continuing unlawful activity, if you do it multiple times as a continuing activity, then you will be charged for organized crime. Alright, that's a separate offense now. So the other parts give punishment for organized crime, 10 years, 5 years minimum, depending upon the crime, etc. Alright. Then we have the next section, petty organized crime. And sometimes it's not huge. For example, kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes. All of these are very dangerous offenses. Alright. These are very severe. But petty organized crime is still organized crime. You can be a phone snatcher, all of that, but that does not constitute or severe organized crime. Whoever, being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers. This happened in many states. Lead paper exam leaks, right, or any other similar criminal act. Right? Basically, less grievous criminal acts is said to commit petty organized crime. Petty is small. Right? Explanation for the purpose of this subsection. Theft includes strict theft, theft from vehicle, dwelling house or business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting, and theft of automated teller machine. Alright, so basically all kinds of these tricks that you touch someone and then someone else pickpockets them, etc. All of that is considered theft for the purpose of this section. Alright, section 112 is petty organized crime. Then we have terrorism. We have discussed this in offenses against the state. It is the exact same definition as section 15 of UAPA. Alright. In fact, explanation to the section 113 of BNS says that an officer of SP rank or above shall decide where to proceed. Do you proceed under the Bharatiya Nyaya Sanhita or do you proceed under the UAPA. Alright. UAPA is Unlawful Activities Prevention Act. So this is the anti-terror law. So terrorism, the special section is Terrorist Act. Terrorism is not defined. Terrorist Act is defined. Okay. So first portion is the intention, that whoever does any act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, economic security of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or in a foreign country. Alright. So you need to have the intent to either threaten the unity, integrity of India, or intent to strike terror or likely to strike terror. Right. Economic security is also included. So it's not just the physical security but also the financial system, that if you target banks, etc., that will also be terrorism. This was the intention. The act is by using explosives, lethal weapons, noxious gases which can cause death, injury, damage to property, hurt monetary stability of India, cut off essential supplies to any community. Many times this was happening, that one terrorist group, especially in the northeast, they would try to cut off supplies to, especially in Manipur, Nagaland, all of these areas. They would try to cut off supplies by the government to any of their rival regions. Damage government, defense or other establishments, all of that is, or overalls by criminal force or attempts to cause death of any public functionary. Right? That we have seen that governor will be killed, president will be killed, all of that is also offense of terrorism, terrorist act. Detains, kidnaps, abducts any person or, and threatens to kill or injure such person in order to compel government of India or a state or any foreign country or international organization or any other person to do or abstain from doing any act. Alright. This last, any other person, has to be seen in light that many times kidnapping is for a terrorist purpose and not just for individual extortion purposes. Right? That will be organized crime. Then we have the offense of treason. Okay. Treason as an offense. This is in very brief. The actual section is much bigger. So please go through the actual section itself. Right. The official name is not treason. The official name is acts endangering unity, sovereignty and integrity of India. Okay. Whoever purposely or knowingly by words, either spoken or written, or by signs, or by visible representation, or by electronic communication or use of financial means or otherwise. Alright, so these two new things have been added. This is basically the replacement of sedition. Sedition has been deleted in the Bharatiya Nyaya Samhita. We have already discussed this section. So whoever by all of these means, including electric communication and financial means, so by funding, excites or attempts to excite. In earlier sedition, it was the offense of disaffection, but now it is secession, armed rebellion, subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges or commits any such act. Right. So now we do not know what the word subversive activities means. This has been criticized that earlier sedition had the word disaffection, which was disaffection was also very vague. Now we have subversive activities, which can also be very vague. They shall be punished with imprisonment for life or with imprisonment which may extend to 7 years and shall also be liable to fine. And the explanation, if you read section 152, it specifically distinguishes the offense of treason from the offense of sedition. It does not mention sedition, but it says that it is hereby clarified that comments expressing disapprobation of the measures or acts of government with a view to obtain their alteration will not be a offense under this section. So this has been specifically added that disapprobation does not mean disaffection. This was the major line in Nehendru Majumdar versus Emperor when we studied the sedition law. So this law has been incorporated as a clarification explanation for treason. Then we have some basic other sections. Attempt to suicide, to compel any lawful power, either compel or restrain any lawful power, alright. The attempt to commit suicide, to compel or restrain exercise of lawful power is now an offense. Earlier, many people who want to demonstrate end up threatening the administration that I will kill myself unless this particular act is done. That is not how government can run. They have to run on democratic principles, constitutional values. So any attempt to commit suicide, to compel or restrain exercise of lawful power will now be an offense. Alright. Attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year. Simple offense, alright, or with both or with community service, so that the judge can now decide how to make a better example of this individual, right. Then we have snatching, section 304. Theft is snatching. You need to have theft before that. In order to commit theft, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. Alright, it's movable property from someone's possession, but not just without their consent, but with suddenly or quickly or forcibly. Alright, whoever commits snatching shall be punished with imprisonment of 3 years and shall also be liable for fine. This is a separate offense. The offense of theft also has a punishment of 3 years, but we will just see the change that is brought in the theft section. Alright, we have in punishments, we have a new section called community service. This has been introduced for a limited set of offenses. Alright, public servant, if they are unlawfully engaging in any trade under section 202, they can be punished with community service. Non-appearance by a witness in response to proclamation published under section 1 of section 84 of BNSS. If you call a witness that you need to give a statement and they don't arrive, then they can be punished with community service. Attempt to commit suicide, we just saw, to restrain exercise of lawful power, section 226. Now remember, attempt to commit suicide in itself is not an offense. That has been decriminalized completely and it has now been shifted to Mental Health Care Act only. Petty theft, on return of the theft money and if the person is convicted for the first time. Alright, this is a new reformatory idea that if the property stolen was less than rupees 5,000, alright, there's less than rupees 5,000 and if it is returned to the person, if it is done for the first time, there are 3 conditions. It should be less than 5,000, it should be returned to the person and the offender should be a first time offender. Then they can be punished with community service. Right? Section 303 3 proviso. Right? Misconduct in public by a drunken person is section 355. To prevent alcoholism from turning into a menace, you can just order community service. This helps them become better individuals instead of becoming criminals. Right? So that is the idea. And defamation can also lead to, in the 356, that can also lead to community service. This is a very good example, theft under section 303 of reformatory justice. If there is a repeat offender, if they have committed the crime multiple times, then there is higher punishment of up to 5 years. Remember, theft was otherwise maximum of 3 years. But for repeat offenders, it is up to 5 years with a minimum of 1 year. That now punishment will range from 1 to 5 years, not 0 to 3 years. Alright. Simultaneously, first time offenders will be stealing if they are under stealing rupees 5,000. If they restore the property, then they will be given community service. Alright. So the first time you get a better chance to become a better human, that don't steal again. If you repeat the crime, it is up to 5 years, higher punishment with a minimum of 1 year. Alright. But for example, if you just commit a theft of rupees 20,000 rupees, that will give you a regular theft charge, then you are not capable of getting the community service system. Alright. So this was the Bharatiya Nyay Sanhita in general, all the provisions etc. that we have covered. Please make a note of them. It was just, this class was just to ensure that all of this gets consolidated and you can see all of the new reforms in the criminal laws in a straitjacket manner in one place. Alright. Thank you.